In a previous video, we talked about the fact that a victim really has no say in how a case is handled, at least as far as in dropping prosecution or dropping the charges once someone is arrested and the case is filed. The question then becomes, how do they prove their case if you don't have a willing victim or a cooperative victim? And there's several answers to that. One just has to do with basic rules of evidence. And one of the rules of evidence is what's called an exception to the hearsay rule. Hearsay generally prevents you from coming into court and testifying about what somebody else told you. However, there are a lot of exceptions to that, and one of those exceptions is what's called the excited utterance exception. And basically, that exception says that if somebody makes a statement after some kind of startling or traumatic event, that statement is admissible. The reasoning behind it is that if you're making a comment or you're making a statement about something that just happened or some kind of traumatic event, you don't generally have time to reflect upon what you're saying, so what you're saying is probably accurate and truthful. In other words, you don't have the time usually to sit down and plan out some kind of falsehood or some kind of lie, maybe to get somebody else in trouble. So there are several basics that are requirements that the state has to meet to get that in. But usually, if a statement is made pretty shortly after an arrest while somebody is still experiencing that event or going through it, that's going to be admissible. The same thing goes for statements that are made during any kind of police call or call that are made for services. So in that case, you may not have a victim testify, but you may have a police officer or whoever makes the first contact come and talk about not only what they saw and what they observed, but what also was said to them.